Next, I have the pleasure to introduce James Saki Youngblood Henderson. James Saki Youngblood of the Native Law Centre of Canada at the University of Saskatchewan. James Saki Youngblood Henderson is a leading Aboriginal legal scholar whose extensive research and advocacy on Aboriginal and treaty rights led to the constitutionalizing of these rights and as a guide to litigation. He helped generate Indigenous diplomacy in the UN system and the Declaration of Rights of Indigenous People. His reliance on Indigenous knowledge and legal tradition has significantly influenced Canadian thought on creating trans-systemic methods to replace Eurocentrism. Professor Henderson.
Machokma Malawalo Piok. Merci. I'll now return to English, which is my third language, and try and explain a little bit about what my work is, since it's really a battle between knowledge systems. It's about a Indigenous knowledge system and how it works within the Eurocentric knowledge systems. And all my work up to date has been to create national and international legal framework to generate a just society from a particular Indigenous knowledge point of view. The framework we developed in the Constitution and the framework we developed in international human rights are both based on trans-systemic analysis that includes both Indigenous knowledge traditions and the Eurocentric knowledge traditions. But we've created these frameworks against a background of intergenerational Aboriginal nihilism and colonial thought. We've not been able to resolve the fundamental framework of the colonial thoughts in the frameworks, and we still confront a very tricky artificial entities and societies where the spirit continues to struggle against the structure and where ideas encounter interest. The overwhelming work of my scholarship and my books and my articles and my constitutional negotiations for the Assembly of First Nations from 1978 to 1993, and my over 50 litigation designs on Aboriginal and treaty rights, has been really to show one point to Canada and the world, and that is Aboriginal sovereignty, knowledge, legal traditions, and treaties are the basic norms of North America. And how these encounter the norms of European sovereignty is the continuing work we go through. That I've been fortunate enough to have the principles that I articulate been accepted by the Supreme Court. I have to say that very few trial courts have accepted it, but it's only been accepted at the highest levels, and that's a continuing mystery, even under the idea of stare decisis. But the idea that Aboriginal and treaty rights are generated not from Eurocentric knowledge, but from Aboriginal knowledge systems and legal systems is the fundamental promise of Canada, and also has created the legal and political need for constitutional reconciliation based on a trans-systemic understanding of Aboriginal law as it informs Aboriginal rights, and Aboriginal law and British law as it forms the rights of treaty rights in Canada. The focus of the more than 400 treaties have established the relationship between the Aboriginal sovereigns and the European sovereigns, and it's been acknowledged by the court that this is shaping the structure of Canadian society in the past and in the present. The idea behind this is what I've articulated as treaty commonwealth or federalism, which is a fundamental level of federalism in Canada, which both provincial federalism and Canada is built upon. And this has been built and constructed from many different worldviews and the will of many sovereigns, not one sovereign. So unpacking it, it's a huge process. That the understanding of the quest for treaty rights and Aboriginal rights has been very complex and very somewhat disappointing to all of us in litigation, that the Supreme Court usually gets it, but the reasons that they articulate for why they get it are mostly wrong, that they still haven't been able to overcome the common law or civil law tradition to understand the Aboriginal traditions. Most importantly, they have, in matters of procedure and evidence, they have had a difficult time of trying to conform the procedures of the court and the evidence of the court to constitutional supremacy that says everything below the Constitution has to conform to the Constitution. And the court has been reluctant, but eventually have confronted this and know that they have to be impartial and they can't go to their Eurocentric biases or traditions when they start to look at all the evidence of Aboriginal rights or title and things like that. But the fundamental problem that is generated, at least to me and my writings are now seeking to try and explore, is that why is it that social theory and normative theories don't have a coherent way of thinking about how to decolonize or restructure any society? That all the Eurocentrism seems to be an elaborate justification for what is and what is status quo. But once you start peeling away why that isn't a valid or a truthful or an accurate description of how Canada came to be, then we run into a vast emptiness and insecurity about how do we talk about the problem. And we haven't developed a good vocabulary for doing that. The court usually tries to use Roman concepts such as sui generis or something like that to cover over that they really don't know what they're doing, and we don't know how to advise them how to do it because we only meet with them periodically once every 4 or 5 years in litigation. So with the emergence of the colonial spirit in its manifestation of globalism, or Eurocentric kind of globalism, I've also had to work on a similar theory in the United Nations, and I've sought to include Indigenous people into Indigenous human rights, to create a human structure for the rights of people, to make the world more just, to generate a framework that protects Indigenous knowledge and heritage, and to generate a theory of peoplehood that may be more essential than the idea of the nation states, although it's still very controversial. But in the 30-year effort in the United Nations, we have succeeded with all my colleagues to acquire the UN Declaration of Rights on Indigenous People and many other normative documents that is establishing a global framework. That while we've accomplished these framework tasks, the task of implementing the framework has been more disappointing. It has many aspects which I can't go into, but we've tried to explain or show through the Indian residential schools how the nihilism, the intergenerational nihilism, was created by the education system. It's still growing. It's not becoming less because our populations of Indigenous people and Aboriginal people in Canada are basically teenage populations, and they have the difficult problems of finding meaningfulness in what they're supposed to be doing. And we also have to work in a system that both the Supreme Court and all the commissions have said is a broken legal system for Aboriginal people, and it makes it very difficult to move through the courts to create constitutional reconciliation. Thank you for this.